Well, that's the issue on the front burner today. But just before we bring in our guest, let's welcome Markwe this morning. Good morning, Markwe.
Good morning, Ayo.
Well, we're going to the issues now, and I'm pretty sure it's something you would want to weigh in on as well. But let's go straight into the conversation with Imam Onike Abdulaziz, who is Chief Missioner of NAFSAT. He's a member of the American Academy of Religion, a member British Association for Islamic Studies. He joins us virtually. Good morning, and thank you for joining us this morning. We can't quite hear you. Maybe you want to unmute your mic, sir.
Oh, I'm sorry.
Okay.
Good morning. How are you?
Very well, thank you. Good morning. Well,
I'm highly honored to be here.
Thank you for being here. Well, I'm sure you know, of course, what the issues are, but for you, what are the important elements to consider in this matter, especially when it comes to peaceful coexistence against the backdrop of what happened in Sokoto State?
Thank you so much. Some of you must have read my press release. It was released on a day after the incident, and I made it categorically clear that our religion abhors jungle justice. But we don't have to scratch the issue on the surface. We have to go deep down. And everybody has a responsibility in this issue. The religious leaders who are preaching it, the political leaders who are left to make populace of our youth unemployed, and they have become the willing tools in the hand of the perpetrators of this act. Then the parents who have left their responsibility of taking care of their children, everybody has a role to play. Then another one is sincerity of purpose. Some of us are paying lip service to this issue of mutual understanding, peaceful coexistence, good interfaith relationship. People are paying lip service to it. And I'm going to cite so many instances. We have seen a video that went viral some time ago. It's still in the cyberspace, where a religious leader, and a clear religious leader, was trying to incite his congregation to kill people from particular ethnic tribe, ethnic extraction from Nigeria. And he was saying, if you see them, kill their animals, attack them. What I'm saying in essence is that we should stop paying lip service to this issue of mutual tolerance, peaceful coexistence, good interfaith relation, and be practical about it, and be sincere about it, and go the whole hog by reorientating ourselves and determining that we want to change for better. Otherwise, the cycles continue. Because I'm not taking the killing of Deborah, the gruesome murder of Deborah Emmanuel in isolation. I'm taking all the issues, all the extrajudicial killings, all the inhumanity that we have meted with one another. I'm taking them into consideration. I'm talking holistically, I'm talking globally, I'm talking generally now, that we need to reorientate ourselves. It is when this issue like this comes up that we see a lot of people trying to talk in a soft tone. Whereas when they get back to their congregation, they'll be preaching this different thing. They'll be inciting them. They'll be promoting hate speeches. We need to change. And Reverend Martin Cooker has made a statement, even though it's not someone that I quote regularly, and I like you so much for being objective. It's one of the messages that you flashed before the beginning of this program. It said, what happened in Sokoto had no religious affiliation. And I want us to go on with that. Most Nigerians will jump to the conclusion, whatever an issue happens in the north, and they will link it to religion. Whatever happens, an issue happens in the southwest, they link it to OPC. Whenever an issue happens in the east, they link it to IPOP. Even if a couple fights in the north, they say, oh, Syria has come again. I like the way you are flashing the statement credited to Reverend Martin Cooker, and that has summed up the feeling, the expression, the position, the view, the perception of the entire Muslims, that this has nothing to do with their religion. Our religion is a religion of orderliness, a religion that has processes, and people need to understand, and we have said it on several occasions, and we have promoted that national liberty, that the objective of our religion is to promote benefit and remove harm. Whatever God that arms has won, that violence has won, that injustice has won, that cruelty has won, that corruption has won, whatever God it has won, Islam condemns it in totality. Even if the promoter of injustice, if the promoter of corruption, if the promoter of cruelty, if the promoter of foolishness is citing Quranic text or hadith to justify his claim, it means he's the one who has not really understood the message of the lawgiver, our creator. وَمَا أَرْسَلْنَاكَ إِلَّا رَحْمَةً لِلْعَالَمِينَ. That ayah summarizes the essence of Islam. Allah says, we have not been sent except as a mercy to the entire mankind. Whatever runs contrary to mercy is not part of our religion. And I go back to my initial introduction that we need to go back to the drawing board and agree to live together peacefully. It is when issue like this comes up that everybody be condemning it. But people have been preaching it. They have been inciting their congregation to attack Muslims, to attack the Fulani. It means we have a lot of role to play. We should respect individual religion, individual ideology, individual belief. It's a sinful thing in Islam for you to abuse somebody else's God. It's condemned in the Quran that you must not abuse their God. In Yoruba language, it is said that somebody who abuses somebody else's father does not respect his own father. If I abuse your father, if I force your father, it's so the kind of position that I put my own father. If you abuse somebody else's God, it means you don't recognize, you don't respect your own God. Next fact, Islam does not have a place for jungle justice, no place for extrajudicial killing, no place for vigilante acts, vigilante killing. And we condemn it unequivocally, and we continue to condemn it, but it goes beyond condemnation when an issue like this comes up. It's a role that all members of the society, the religious leaders, the political leaders, the parents, the role we have to play. If you teach our children right from home that we should respect other people's ideologies, respect other people's religion, respect other people's belief, don't insult their intelligence, don't incite this kind of thing that you are seeing will not happen.
Having given that background, in fact, referencing Bishop Coker's statement that there's no religious, this is not a religion thing. I'd like to know how then should people place those who have supported the act both on and off social media. We've seen protests from people saying that those who have been arrested in connection to that gruesome act be released. So how do you then place those people who say, well, this is how it should be done, what was done was right, and we stand by it?
There's a Yoruba proverb. I'm going to say it in Yoruba, and I paraphrase it in English. It says, whoever kills his mother, we have a supporter. If you kill your mother now, some people will support you. They will say, oh, maybe the mother has done something bad. But you won't see a voice in Islam. Our leader has spoken. The leader of Muslim Ummah in Nigeria is eminence. Sultan Abubakar, Sultan of Alhaji Abubakar Saad. He has said it, he has represented us, and has said the position of Islam. If anybody is now justifying this killing, the person is on his own. And they have to point at the Quranic verse that says that you go into extrajudicial killing. If somebody commits somebody has done something that's blasphemous, the court is there, the law is there. Take him to the law court, let him prove himself, let him defend himself. It is not your own. It's not within your authority to take laws into your hand and you kill. Quran chapter 5 verse 32 is very clear. Whoever kills his soul, man qatala nafsa bighairi nafsin aw fasadin fil ardi fakana ma qatala an-nasa jami'a wa man ayaha fakana ma ayana an-nasa jami'a. Said whoever kills his soul innocently and without that soul having committed any crime, and without you taking that case to court, it's like you have killed the entire mankind. And whoever makes his soul to live, it's like you have given life to the entire mankind. That shows the gravity of murder in Islam. No justification. There's a process. You take the person to the law court, let him prove himself. Moreover, we have a school of thought that says that a non-Muslim, another school of thought, a non-Muslim cannot even be charged for blasphemy because there's no offense that's greater than saying that God has a child. He has blasphemed several occasions. If you not say something again, what he has done before, his belief is that your God is not his God. He doesn't respect your God. If you say something bad, his school of thought says, that shows his ignorance. Ibad Rahman. الذين يمشون على الأرض هونا وإذا خاطبهم الجاهلون قالوا سلاما. The servants of Allah, the most merciful, they walk on the surface of the land without any arrogance. They maintain humble gait. And when they are accosted by the ignoramuses, when they are accosted by those who don't know what they are doing, they will say, peace. I'm innocent. I don't want to talk to you. That is what Islam preaches. But as I said earlier on, mutual understanding, mutual respect for each other's religion, each other's belief, each other's ideology goes beyond what happened in Sokoto. What do you say about those who say that this is the way my religion says as we dress, as we put on hijab, and people are going to war, people are victimizing them because of that? It goes beyond the moral scaling. We condemn that, we continue to condemn that. But we need to go back to the drawing board. Since we have agreed that Allah has created us to live together, we shouldn't pay lip service to peaceful coexistence. We should stop paying lip service to mutual law. We should not pay lip service to mutual tolerance. We should go the whole road by practicalizing it, by demonstrating it, by internalizing it. And by letting the whole world see that we're ready to live together. Because if Allah had will, he said, if I had will, I would have made it to be one group. There wouldn't have been Christian, there wouldn't have been Muslim, there wouldn't have been other worshippers. Who are even we to fight for God? Who are we to fight for God? But we should know our boundary. It's good to preach, it's good to evangelize, but respect other people's feeling, respect other people's religion, respect other people's ideology, respect other people's God. That is the point I'm making. Don't victimize them on the basis of their religion. Don't victimize them on the basis of their tribe. Don't victimize them on the basis of their class. Islam is a religion that preaches law, that preaches peace. And this is not something we are saying to massage our ego. The country with the largest number of Muslims, with the largest population of Muslims in the whole world, is Indonesia. About 98% of Indonesians are Muslim. No religious war, no Islamic war has been ever fought there. And they are embracing Islam. Go to the West now. Go to the Europe, go to America, go to countries that were treating Islam as an alien religion before. A lot of them are embracing the religion now. Not that we are saying it, it's not a matter of something like okay, they're just saying it. Going back to the question, that the people who are hailing the killers of the Quran, that does not have any support in Islam. As I said, if you kill your own mother, if you murder your own mother, your mother that gives birth to you, you are going to get supporters. You are going to get those who will hail you, that you have done well, that, oh, well done, bravo, for what you have done. We are not surprised that people are hailing it, but when you look at the issues holistically, and once you have agreed to live together peacefully, we should stop the religious leaders who are fanning the embers of discord. If you want to be sincere with me, some of you have come across that video, and the man of God has not come out to deny it till now that the thing did not originate from him. He was inciting the audience. He was inciting the congregants that go and kill the Fulanis, go and maim them, go and kill their animals. That is condemnable.
Chief Imam, thank you for providing clarity, particularly citing the Quran, and of course also supporting it with cultural examples, which is why I want to ask if there is a consensus, amongst Muslim scholars on how to respond to Deborah's comment. I ask because there are some who, like you, have condemned the mob action, but there are some who position to say that insulting the Holy Prophet, peace be upon him, is the red line for Muslims. What are your thoughts on this?
We are talking of two issues here. We are talking about insulting someone that people revere, someone that people revere, people respect, is one thing. That shows your level of morality. That shows your level of own training. But judicial killing is another thing entirely. It's clearly stated in the Quran and Bible. I will quote it out to you in the Bible that you must not insult God. Even the New Testament says that you must kill whoever does that. But that's one thing entirely. Another thing is judicial killing. Another one is insulting some people that somebody that people respect, people worship, people consider to be their ambassador, their teacher, their idols. Insulting him or her is another thing entirely. Judicial killing is another thing entirely. I didn't lose the fact, didn't forget the fact that that one is condemned by any sensitive person. You cannot insult anybody's religion. You cannot insult anybody's God. That is one side. Everybody, so that when people make comments, you have to separate it. You have to look at the actual argument. Those who are saying they are crossed the red line, are they supporting extrajudicial killing? That will be made clear. Are they supporting jungle justice? That's because if you start it, you wouldn't know where it's going to end. And I say it's holistic, it's global, it's not something that we take in isolation. We condemn the animal killing, which has nothing to do with religion. We condemn the killing of Fulanis in some locations, which has nothing to do with religion. We condemn the maiming of Igbos in some locations, which has nothing to do with religion. Animalistic tendencies, animalistic behavior is what we are condemning, and in Israel and in Islam, we continue to condemn. If you are saying that somebody made a statement that you don't cross a red line, that is on one side. Don't cross the red line, because the red line, the law, the arms of the law will take care of you. You'll be charged to court. The process will be gone through, and if you are found guilty, you'll be dealt with appropriately. Another one is jungle justice. I hope I'm making my point. There are two things that when you are asking people's questions, so that you don't put them out of context. You have to be fair to some people. You have to be fair to some people. That number one, everybody, every right-thinking person, every sane person will condemn extrajudicial killing, because that will lead to anarchy. Even the scholars who have quoted, you are referencing. If you ask about extrajudicial killing, he will tell you, no, that is not allowed in Islam. Number two, what about blasphemy, insulting other people's God? He will tell you that that is condemned. It's a red line for any religion. Please, when quoting someone, and that's why I like the electronic media, I prefer electronic media, because people can easily look back at what someone has said. Don't quote people out of context. I'm not quoting brief for the man, but I know if you come somebody, an Islamic scholar, who knows his onions, who knows the Quran and Sunnah, he will never support jungle justice. People will say, oh, they are picking the red line, which is a red line to every religion, which Bible condemns in about three locations in the Bible. Some may say inside the Old Testament. When you say the Holy Bible, the Bible means the Old Testament and New Testament. He condemns it. Quran condemns it. Every religion condemns it. Even we are not expected to abuse the idols in Islam. Because if you abuse what the idol was about was, if you abuse your own religion ignorantly, and you are the one that have put insults on your own God, that is one thing. Extrajudicial killing is one thing, except you are telling me that that man has killed behind those who have committed the act, the offense of extrajudicial killing. Except you are telling me that. But let's separate the two arguments. Abusing somebody else's God is condemned by all religions.
If I may come in, Imam, I'd like to, I mean, you've spoken about how hypocrisy also has a great deal of role to play here, but there are questions as to how we can reconcile. I mean, sadly, Deborah did not go through the due process. We understand that the Sokoto state government say they are still investigating. So it's not very clear. We know the incidences that have been reported, which eventually led to her death. But I mean, she doesn't have benefit of the doubt to be able to say precisely what she said, or we're not privy to the particular WhatsApp message which was said to have, offended and led to her death. But this is what we have. You've also blamed hypocrisy having a great role to play in this. How do you think that this can be cured?
We continue to allow the text to speak to us. We continue to teach people the fundamentals of our religion. And that's what National Advert is promoting. We are promoting what we call principle of Islamic jurisprudence. So that even if anybody is giving a fatwa, you should let us know how you arrive at that fatwa. Number two, we are teaching people the objective of our religion, which is Maqasid, the Sharia. And I've told you, Jalib al-Masali, Wadarib al-Mafasid, promotion of benefit and removal of harm. If somebody has been told, and somebody has had the orientation that my religion preaches peace, my religion is about mercy, my religion is about justice, my religion is about wisdom, and my religion is about goodness. If anybody is telling him something else, he will want to go and seek for second opinion. But if what the scholars are telling you, the imams are telling you, the church leaders are telling you that, oh, these people are your enemy, and they cannot quote the Quran, they cannot quote the Bible. Even if they quote the Bible, you let them know fundamentally that our religion is for peace, our religion is for mercy, our religion is for goodness, our religion is for justice. Once people are told all that, if anybody brings a ruling, there's something they call BODMAS in arithmetic. If you arrive at an answer and you have not applied BODMAS rule, your answer is faulty, you have made a mistake. People need to be taught the objective of our religion. Once they know that whatever you want to do, you must consider the public benefit. There are situations when people stole, and the leader, the caliber, they said that whoever has stolen in this period because of famine, because of scarcity of food, don't apply Sharia law. That is our religion for you. The spirit of the text and the rule of law. Can you look at the spirit that what does Islam want to achieve? Islam want to achieve peace. Islam want to achieve harmony. Islam want to achieve justice. If anything want to block that achievement, want to discourage that achievement, you will take it aside for a while. And that is our religion. People need to know the objective of our religion. People need to know how to arrive at making ruling. We are not turning them to scholars, but you may not be a doctor. If a doctor prescribes 10 paracetamol for you in the morning, 10 in the evening, 10 in the afternoon, you will not take it. You will say, oh, what I've heard is that you cannot take more than 2. Let me go and seek for second opinion. We are imploring our people that we know those who have studied this religion. We know the overnight imam. We know the overnight pastor. That somebody who has retired because he has nowhere to go again. He let me take up the Bible. People like that may not allow the text to speak to them. They be speaking to the text. And when you are speaking to the scriptural text, you get whatever interpretation that you want to get. When you pass through the rudimentary stages of applying scholarship in Islamic studies, rudimentary stages of applying study in biblical studies, you will not do certain things. And that is why I want to go back to it. The religious leaders who are preaching.
Imam Abdulaziz, if I may interrupt you for one moment, are you a little troubled that this happened within a school?
Within? I can't hear you.
Are you a little troubled that this happened within the precincts of a school, institution of higher learning?
Regardless of whatever has happened, you are taking the issue in isolation. The act of killing happened inside the house.
Yeah, it looks like it's If you can hear us, can you hear us? It looks like the visual is frozen. I was asking Imam Abdulaziz if he was troubled that this happened within the prisons of a school, but looks like we have. Okay, he's back now.
It has happened in Port Harcourt. If you don't forget it, we can't forget in a hurry. The Alu killing. We didn't take the Sokoto incident in isolation. The Alu killing is still fresh in our memory. It happens in the school. It means generally we have failed as parents. We have failed as a religious leader. We have failed as political leader. If it had happened in the home, we would have held it. We wouldn't have held it. We wouldn't have supported it wherever it has happened. It's a condemnable act to get involved in extrajudicial killing. It's a condemnable act to abuse somebody else's God. It's a condemnable act not to promote peaceful coexistence and good interfaith relation. That is the point I'm trying to make. Regardless of whatever it has happened, if it has happened in somebody else's residence, people will have condemned it. But I know the point we're trying to make. The point I'm trying to make is that it happened where people's morals, people's attitudes are supposed to be molded. This is not the first time. It is not something that we want, not something that we want to promote, but we should look at the issue from the root, not at the end. In Yoruba land, it is said that somebody with a bow leg is carrying a load. And you're looking at the load, and the load is not straight. And you are saying, this load you are carrying is bent. Look at the leg now, look at the feet. He's having a bow leg. What do you expect the load that is carrying to look like? We should orientate ourselves. We should look at religious studies again. The parents who are not teaching their children to respect other people's feelings, the religious leaders who are promoting hate speeches, the political leaders who are exploiting the poverty level of some people.
Okay.
I wouldn't say literacy level now, because it happened in the school. They are literate to some extent. But you may go through the university, and the university may not go through you. It's a different thing entirely. You may think that you have education, and mentally you are not developed in any way.
Okay.
You can be brainwashed.
Well, Imam, you have, you've assigned and literally apportioned everyone's, plate to him, so to speak. The government has its roles cut out for them. The schools have their roles cut out for them, and the religious leaders themselves have their roles cut out for them. I just hope there is, especially among religious leaders who model people's thinking and actions, have a way of also editing themselves so that these things can be nipped in the bud before it spirals into what it has become. Imam Abdulaziz Unike Abdulaziz, Chief Missioner of NAFSAT, member, the American Academy of Religion, and member, British Association for Islamic Studies. Thank you so much for your perspectives this morning.
Thank you so much for inviting me.
Yeah. So we are back after this break. Please stay with us.
No political appointee at any level shall be a voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. This is Section 8412 of the amended Electoral Act, which was signed into law very recently by the president. Even when he signed that amended Electoral Act into law, he pointed out this particular part of the act, saying that this was a part which he had serious objections to. Well, finally, himself and the Attorney General of the Federation have approached the Supreme Court for an interpretation of Section 8412 of the Electoral Act. We have with us this morning Mr. Kehinde Eleja, who is a senior advocate of Nigeria, joining us via Zoom to shed a little more light on what this particular section says and what exactly is causing controversy on this particular matter. Thank you so much for joining us, Senior Advocate of Nigeria, Mr. Kehinde Eleja. You've seen the process that this particular act has caused us to take. We've seen what the Federal High Court said in Umuahia. We've also seen the Court of Appeal step into it. Interestingly, the Court of Appeal talked about a lack of jurisdiction that the Federal High Court had in Umuahia, but went a step further to say that if it were to determine the case on its merits, it certainly was going to say that Section 8412 was not consistent with the Constitution of the Federal Republic of Nigeria. And right now we've seen that finally, it's on its last leg, the President and the AGF have finally approached the Supreme Court for interpretation. Did you find the ruling of the appeal court a little interesting?
First of all, let me say good morning, and it's my pleasure to be on the program. Now, considering the background of the matter, you will recall that Section 8412 was introduced via the recent amendment to the Electoral Act, like you have said. And the implication is that it seeks to disqualify or disentitle some political appointees in the categories of ministers of federal government, special advisors and commissioners and special advisors at the state level from being eligible to vote as delegates at the convention of their respective political parties to elect flag bearers for the purposes of the 2023 election. It goes further also to prevent this category of individuals from being eligible to be elected as flag bearers for their respective political parties. The trajectory of the case is quite interesting. A private individual approached the court to challenge this provision. Incidentally, he was neither a candidate or a person that was interested in contesting at any of the conventions of the party. But he nonetheless filed the matter in Umwa here, and a decision was rendered by the Federal High Court annulling that provision and directing the Federal Attorney General to ensure that that provision was deleted from the law. An appeal was filed, incidentally, by the PDP, who was not a party to the proceedings at the Federal High Court. That party obtained leave as an interested party, and the Court of Appeal had to resolve that case without the necessity of delving into the merit of the issues that were adjoined as such, because it was found that the plaintiff that approached the court actually lacked the local standard. That is the standard to show he never showed sufficient interest. And because he didn't show sufficient interest, the court also found that there was no cause of action. That is to say, there was no life issue to be determined by the court between the person that approached the court and the person that was sued as a defendant before the court. On that note, the court decided that there was absence of jurisdiction, and accordingly brought the matter to an end. However, as an intermediate court, it proceeded to make a pronouncement on the legality or otherwise of Section 8412 of the Constitution, and the conclusion was that that Constitution was indeed discriminatory against the category of individuals that are affected by that law. Well, the pronouncement of the Court of Appeal, to the best of my knowledge, is not yet before the Supreme Court, but it's a matter of common knowledge that the Federal Attorney General is already before the Supreme Court and the President of the country to invoke the original jurisdiction of the Supreme Court to have that section of the law struck down so that it will allow people to participate in it. Well, at this level, I must say that papers, to the best of my knowledge, have been filed and exchanged by the parties who are involved. And one will have to be cautious and circumspect by way of refraining from making categorical opinions that will undermine the pending matter before the Supreme Court. I rather want to consider what are the issues or what could have informed the decision of the legislature to introduce this kind of a legislation into our electoral law. Like I said, the matter is sub judice before the Supreme Court, and we have eminent counsel representing the diverse interests before the Supreme Court. That is why I want to refrain from making any categorical pronouncement about the legality or otherwise of the said provision of the Electoral Act.
Well, they've quoted many parts of the Constitution which they say that it is in contradiction to. They quoted sections 65, 66, 106, 107, 131, 137, 147, 151, 177, 182, 192, and 196 of the Constitution. They say all of this, given a combined reading, would be pointing to discrimination on the part of Section 8412. I'm wondering what exactly will those who are arguing on the opposing side, because I imagine that when you take it to the court, the Supreme Court for interpretation, maybe there will be those who will offer a counter argument. What exactly will be the counter argument in this case?
Well, honestly, I don't want to be preemptive of the argument that may come from the other side. But you see, provisions of the Constitution are usually not made in absolute terms. For every general rule, there is always an exception. Their strongest argument will appear to be, those who are the proponent of the illegality of Section 8412. Their strongest argument will be that perhaps Section 8412 is discriminatory and offends provisions of Section 42, which prescribes that nobody shall suffer any discrimination on account of his tribe, religion, ethnicity, etc., etc. Well, then if you look at that section of the law, it is not one that is made in absolute terms. I'm talking about Section 42 now. You will discover that there is a proviso there which says that nothing in the provision of Section 42 shall lead to the invalidation of whatever thing that has been done in contravention of that law. If a law has been made in the public interest to protect public moral and so on and so forth, a number of exceptions were recognized there. I think one could seek umbrage under that provision to argue that the intendment of this law is to ensure that those who have been appointed and shadowed with responsibilities of discharging functions as ministers, commissioners, special advisors, and so on and so forth, have a choice of remaining to fulfill the obligations, the responsibilities entrusted upon them by their appointers. At the same time, they have a discretion of leaving government to seek elective positions if they so desire. So a situation whereby you have, for example, a good number of ministers, I think 12 or so of them, who still have about a year to the end of their tenure, now embracing intention to contest elective positions while still maintaining their positions as appointees of the minister of the president, will not, in my humble opinion, all go well for the smooth running of government. In any event, the entitlement to seek political office, in my own opinion, is not something that will be strictly taken as a fundamental right. It's a matter in respect of which an individual has a choice. The choice to either remain or the choice to be opt out and go and face elective position. That's my candid opinion on the point.
One of the questions that come to my mind, Mr. Leja, is you've spoken to it a little, and I would like you to expatiate a little further. There is the letter of the law, which, of course, is the interpretation that is being talked about, and there is also the spirit of the law, which is the intendment that you spoke to earlier. I'm wondering if you think that the spirit of the law, or whatever it is that the law intended, that Section 8412 intended, should be something that's a principle that all political parties should take on without necessarily, putting it into the law, because there are those who will be wondering, you can't eat your cake and still have it in your hand. That's how some people might want to perceive that law. Do you think it is something that should just be known without necessarily even making such a big deal of it to the point that we're taking it to the Supreme Court?
You see, in other decent climes, where people take the act of governance with the requisite seriousness, there won't be need to enact a provision like Section 84 sub 12. But this is our own country, which is an interesting one, in which somebody will want to hit his cake and at the same time have it. I must say that in a number of states, some governors have acted appropriately, even before the decision was rendered by the Federal High Court in Owerri, directing political appointees seeking elective positions to resign their positions so that they could frontally face that issue and allow others to continue with the act of governance, since they still have about a year or even more. So in an ideal setting, it shouldn't take the legislature having to enact this kind of law. But this is Nigeria. And I think that law came about as a result of the need to ensure that for those who are not willing to do this on their own, well, perhaps the law should do something by way of excluding them so that they face whatever they intend to face. You could see the way the matter is even going. The central bank governor, despite his position, is also clamoring now, I want to contest an elective position, considering the very sensitive nature of the office which he occupies and the kind of partnership that had existed over the years between that CBN, which is superintends, and the electoral body, that's the highlight. It's an unfortunate situation. And I think that will also be part of the reasons that would justify the enactment of Section 84(12) of the Electoral Act.
Also, reference. I mean, you've referenced some states taking that action. There are those who also, you may also want to reference what the federal government has done. The president himself putting out a letter and saying, if you want to contest, resign. Do you consider that cheering against the backdrop of the fact that it is the same, president that's gone to court, to the Supreme Court, to seek an interpretation of the law that he is already obeying, it will seem?
Well, if you look at it critically, we discover that the president directive came about the time or after the time that the Federal Court had given its decision. And I want to impute into that an intention not to gamble in case we allow our party members to run and it turns out that Section 84(12) is valid. What happens to those who might have been elected despite the provision of Section 84(12)? So the president's reaction, I believe, came as a result of the decision of the Court of Appeal on that matter, so that the president will appear to want to be careful in taking a decision. Well, having said that, I think it is the entitlement of anyone who is aggrieved to approach the court. Morally, one may say, oh, it probably is not right. But as a matter of the law, the president reserves the right to go to the Supreme Court. Whether or not as either the president or even the attorney general, whether or not they have local standard, will be a different matter at the end of the day.
Since you're rather careful because the case is still before the court and you would not want to preempt, the outcome, I'd like us to dance around it a little, particularly by going back to the beginning, looking at the outcome of the ruling of the Abia Court. CSOs are asking, who is Unduka Edede? What's his interest, set against the backdrop of the ruling of the High Court that said that the man had no locus standi? And why the hurry with which, the case was dispensed with without recourse to the legislators themselves who should have been named as defendants in the case?
You see, we are lucky in this country, regardless of whatever may be said by anybody about our judiciary. We have a very responsible and responsive judiciary. Given the urgency of the matter, with the fast approaching primaries of the political parties, in line with the timetable released by INEC, I think the decision of the Federal High Court to determine that matter expeditiously rather than being condemned or to be commended. And the Court of Appeal, that issue also featured as a point of complaint in the Court of Appeal, before the Court of Appeal. And the Court of Appeal found nothing wrong in the way and manner the matter was expeditiously heard, given the national importance of that matter. Of course, what could not be disputed is that the man that went to court, even from all the processes filed, did not disclose sufficient interest in the outcome of that case. The question again, which the Court of Appeal also adverted to in that decision, had to do with why the choice of Owerri for purpose of such a matter that is of national importance. And the Court of Appeal, in its judgment, was of the opinion that the litigants have a duty to avoid forum shopping, looking for convenient venue where probably they could get amenable decisions of the court. But like it's been said earlier, the principal reason for allowing the appeal had to do with the issue of a local standard of the plaintiff before the Federal Court.
As we wind down on this conversation, I know there's the morality that is being talked about here and there, saying, I mean, it doesn't make sense for you to, as the expression goes, eat your cake and have it in your hand. And I'm just thinking, how far then can we extrapolate this? What's the difference between, just allow me here, hypothetically speaking, a House of Reps member, a senator, a governor seeking elective office or seeking re-election, and a political appointee, seeking election? Because in any case, they will both use their office as some form of, influence and all of that. So really, is that something we should also be looking into? Yes, I know one is elected, the other is appointed, but I think the idea here is using that office, the power of the office, the resources to influence the outcome of the election.
I quite appreciate your point. But we discovered that if you look at the law, for those elective offices, certain definite terms have been created. For example, for the president, a definite term of 4 years has been guaranteed by the Constitution, of course, subject to some other conditions. The same thing with the governor. But for somebody who is a minister, for somebody who is a commissioner, for somebody who is an advisor, such tenures are not guaranteed by the Constitution. Somebody may be appointed today, tomorrow is removed. That is the distinction I could make between the two offices. One, the term is prescribed, it is protected, it is guaranteed. For the other one, the appointive ones, there is no security of terms. So somebody may be removed even the day after he is sworn in as a commissioner, for example.
Pardon me, I understand the tenure. That's why I said I understand. I know one is elected, definitely, so that's backed by law. But I'm saying that that point of using, the instrument of your office, the influence, the resources, I mean, you understand what I mean. So that's the point I'm trying to make, that if we're trying to guard against that with the political appointees and all of that, why aren't we at least speaking about guarding against that even for those in office? I'm talking about the House of Reps members, essentially people elected. Isn't that a conversation we should also be having?
Well, I quite appreciate your point. It's a bit technical, but I believe that this process is an ongoing process. Our democracy is still one that is developing. Maybe at some point in future, matters may also crystallize up to that level.
Talk about the constitutional provision that speaks to, what should be done by someone seeking the office of maybe president, governor, saying that they must resign 30 days before the election. Now, I've heard different interpretations. Some saying, well, it's the party primaries that might be talking about. Some say, well, no, it talks about the general election. But, the Constitution just says the election. And you can actually say the primaries is some sort of election. So how do you interpret that, really? And I'm talking for the current ministers, who some have said, well, it might be too late because the primaries is just a few days away.
I quite agree that there is no ambiguity about that provision of the law. It relates to the proper election. And that is why Section 8412 is particular about party primaries. Somebody voting as a delegate at a convention to appoint flag bearers, or putting himself forward to be appointed as a flag bearer of a political party.
The appeal court in its rulings had said that if it were to rule, that it will rule that it was unconstitutional because it runs foul of Section 42 of the Constitution. But Section 42 of the Constitution speaks to sex, place of origin, and all other related issues. Please clarify how it relates to the dictates of 8412, which the court is trying to say that discriminates against the individual in relation to Section 42 of the Constitution.
My honest view is that Section 8412 is not discriminatory because it cut across every political party. It will have been a different thing if it affects Party A without affecting Party B. If you look at Section 42, which talks about discrimination on account of tribe, on account of religion, on account of faith, and so on and so forth. So you may want to say that even though the principle is the same, trying to provide a guarantee against discrimination, well, I think it will be extended that to be carried out provision a bit too far to insist that Section 8412 is discriminatory.
You know, there's one point we haven't cleared, Senior Advocate, and it's really, what is the state of 8412 as we speak right now? Because it looked like it was deleted at some point, but now...
as we speak now, legally speaking, as we speak now, by virtue of the judgment of the Court of Appeal, which allowed the appeal of the PDP, and they struck out the suit before the Federal High Court, it's as if no action was taken. It's as if no challenge was taken against Section 8412. So in law, Section 8412 is extant, and it will appear that it was in appreciation of that the Attorney General of the Federation and the President had now approached the Supreme Court in the hope that the Supreme Court will accede to their request. So that section is still extant. It is still part of our law until otherwise decided by the Supreme Court.
What about those taking the, comment now of the appeal court, Abuja, which some say remains arbiter, saying that, well, if we were to decide on this, it is unconstitutional. Some have already taken that far, saying, well, that is the decision on this now, meaning that it's unconstitutional. How do you link that up?
You see, legally speaking, once a court says, oh, there is no jurisdiction, it's as if nothing at that point. It's like talking about a building without a foundation. If there is no foundation, you can't be talking of a building. But the Court of Appeal, just as the intermediate court, just decided to exercise restraint in case that matter gets to the Supreme Court, and the Supreme Court will have to pronounce on the merit of the case. Supposing the Supreme Court decides to overrule the Court of Appeal by holding the person that went to court had local standard, and that there was cause of action, and that the proper was properly determined. Of course, the Court of Appeal had merely availed the Supreme Court of its opinion on the matter, so that the Supreme Court will have the benefit of considering this matter, rather than remitting the matter back for the Court of Appeal to consider the case on the merit. So like I said earlier, it remains a mere obiter, it remains a mere observation until validated by the Supreme Court. It does not confer any right on the plaintiff that approach the court and on those others who share the same view with him.
Well, someone else has, of course, there are diverse opinions and perspectives to Section 8412 of the Electoral Act 2022. Here is one.
Assembly was making Section 84 subsection 12 in the amended Electoral Act by saying all political appointees shall not partake, shall not vote or be voted for at congresses or political parties. It was acting ultra vires because the Constitution in section 65, 66, 175, 176, 182, 183 has already told us who can contest elections or who is disqualified from contesting elections. So the National Assembly cannot add or subtract. The court has spoken and it is finished. It is finished. Once the court has spoken, except the people, the defendants in that case, appeals the judgment, and the Court of Appeal sets aside that judgment, and it further goes to the Supreme Court, the final Court of Appeal, and it sets it aside. That judgment remains extant, subsisting, valid, and constitutional.
Well, so much has been said about that already, Mr. Eleja. You have also alluded to that. And of course, the appeal court has since spoken on that. And you said that that addendum of the Court of Appeal may not be as valid as is. But then there are those who are questioning the local standi of those who took these matters to court. The individual who took the case to court in Umar here, and then the political party that, also took this matter up in the Court of Appeal. There are those who are wondering, since they are not parties, should the case even be an issue in the first place?
Whether the case should be an issue in the first place, because that is the essence of what the Court of Appeal has said. You have not demonstrated sufficient interest. Oh, you have not said, I have collected the nomination form. I intend to run for a particular office at the convention of my party, slated for so time. He has not said so. What he has simply said is that, I'm a politician. I have the intention of voting for some people who are appointees, political appointees, and who occupy positions now. Therefore, that is my local standard. The court said no. You can't, on account of that, be trying to invoke the judicial power of the court under the Constitution. So that is the basis. Actually, I believe those who could properly challenge this provision are either political parties or individuals who have the base intention to contest. And those individuals must fall into categories of persons affected by the provisions of Section 84 subject, that is, political appointees occupying positions of either minister, commissioner, or special advisors, and other positions in that respect. So that is my view.
Well, Mr. Eleja, there's also that, as a result of all of these issues that are arising from time to time, it would seem like the Judicial Council or Judicial Commission is beginning to get interested in all of this. Consequently, that guidelines came from the NJC saying these are the things to do, these are the things to not do, especially by heads of court and all of that. First of all, what do you make of all those guidelines, and if you want to reference any specific one, and how they may help to make the electoral process this time around easier and better, or mar the process altogether?
Okay, thank you very much. Now, of recent, the National Judicial Council issued a policy directive, or direction rather, regulating filing and hearing of electoral matters. The background for the issuance of this direction is that it has been shown that when it comes to political matters that have to do with elective offices, a lot of untoward things happen. For example, you see politicians indulging what is called forum shopping. Somebody is filing a matter has to do with a senatorial seat, for example, in Kwara. Somebody is coming to Oyo State, for example, to file an action in the Federal High Court, or is coming to Abuja or elsewhere, the matter is coming from Edo State, for example, somebody is going to Borno to insist an action. People now doing what is called forum shopping, looking for venue where they will get a favorable judgment. We also discovered that their multiplicity is also a common feature. Before now, that you see multiplicity of action on the same subject matter. For example, on a single senatorial seat, there could be up to 6, 7 litigations, cases filed before the Federal High Court in Abuja, another one in Lagos, one before the Abia State High Court, another one before Taraba State High Court, and on and on. At the end of the day, this leads to conflicting decisions. And this is a serious, this causes a lot of embarrassment to the judiciary. It is also not good for image of the legal profession and the country at large. This is the basis why it is the NJC has now deemed it fit to issue a practice direction to regulate how pre-election matters and elections having to do with party primaries and all whatnot will be handled. And the essence of it, or the summary of it, is to ensure that cases that have national feature, that is to say, irrespective of which the issues being sought or the reliefs being claimed, extend beyond the territorial area of a particular state. Such matters ought to be filed under the under the new direction. We now have to be filed before the FCT High Court. Now, where is the matter that is exclusively within the jurisdiction of the Federal High Court? Such matter will have to be filed at the Federal High Court in Abuja. Now, for matters that are limited to the individual states, they must be filed within the states where they arose, so that they could be determined there, so that you don't start gallivanting around looking for favorable judgment or unnecessarily burdening those courts in Abuja. Experience has shown that during election, during the periods like this, you discover that Federal High Court and even High Court in Abuja, they hardly attend to any other matter other than electoral matters. This is also part of the intent and the rationale behind this law. So what has now been said
questions for you. You've been...
Yes, please.
I don't know if you can hear me.
I can.
Two quick questions for you. You were talking about the policy directive given by the NJC. First will be that regardless of whatever the Supreme Court says, do you think that a president in future can ask members of his cabinet to resign if they have political ambition, regardless of whatever it is, regardless of whichever way the Supreme Court rules concerning Section 8412?
Thank you very much. These individuals are appointees of the president. They are appointed at his pleasure. And he who that hires in this circumstance has the power to also fire, regardless of the decision of the outcome of the case before the Supreme Court. It is the discretion of Mr. President to relieve any minister or advisor of his position at any time.
But it would seem that, you know, the Electoral Act, despite the painstaking efforts which the National Assembly put into it, and remember the clamor from civil society organizations, and when it was eventually passed on to the president, the clamor also for him to sign. Eventually, he did sign, and it came with this objection, so to speak, which has now found its way up to the Supreme Court. We found out that Section 84(4) of the Electoral Act, it would seem, was an error. That's what the National Assembly said. And only last week they sat to amend the Electoral Act 2022 once more. I do not know if you noted that particular exercise and what you made of them amending Section 84. I mean, Section 84 seems to have lots of issues. If it's not controversy, it will be error. Did you take note of that particular exercise, and what did you make of it?
Quite honestly, I have not averted my mind to that. I was not aware any such exercise took place. Okay,
I'm trying to get out the particular, yes, this is it now. just noting, last week the Senate did amend Section 84.8, beg your pardon, it was not 84.4, 84.8 of the 2022 Electoral Act, and they said the clause was to amend an error which should allow statutory delegates partake in party primaries. It was to make provision for delegates who will not be elected as ad hoc delegates to participate in the conventions, congresses, or meetings of political parties. I do not know if perhaps in the efforts to try and ensure that, political appointees do not participate as delegates, perhaps there was an error or an omission made which was preventing delegates who will not be elected from participating in the conventions, congresses, or meetings of political parties?
Well, clearly from what you have just read out, it's very evident that in a bid to bring in this section 84.12, it will appear a blanket provision was initially made in section 84 sub 4. Now, having realized that, they went back to see to it that statutory delegates will take part in these congresses. Ordinarily, ministers, commissioners, special advisors, ordinarily under the respective constitution of the leading political parties, are statutory delegates. So what they have done now will appear to be that we know those that we want to exclude, and those are the people in the category that have been mentioned in section 84.12, while other delegates will remain as a statutory delegates. I think that's what they are just trying to do. I think it's trying to work in harmony to bring section 84.4 in harmony with section 84.12 of the Electoral Act.
Okay. Well, there's also the talk, we've not been able to confirm this independently. There's also the talk that currently existing are public service rules, which already stipulate that, public servants, and that includes civil servants as well, should, resign from office if they seek political appointment. I do not know if you're privy to any such rule, because we also saw what the CBN governor tried to do by also going to court to say that he is exempt from, some of those rules. Whichever way this judgment swings, that's the section 84.12, do you think that it's going to be problematic for any public service rules if they do exist in that regard?
I do not share that view. I think the public service rules relate to a certain category of persons, those who are civil servants. They are different from political appointees. And my take is that it is clear now that politicians could take part, civil servants could take part in political parties' activities. They could even aspire to be elected. Of course, subject to the rule of having to either resign their position or seek leave of absence at least 30 days before the election. But then again, they will still have to come to terms with the problem created by Section 84.12 now for, beg your pardon. Okay, that is not, Section 84.12 is not applicable to them. They can't take part in the party activities. They can't put themselves forward, of course, subject to the resigning at least 30 days before the proper election is held.
The question I'm asking is whether or not, can they too claim discrimination? Aren't they being discriminated against by virtue of whatever it is that they, whichever way this judgment swings? Can they too claim that they're being discriminated against, being prevented from contesting or having a political life because of their position as civil servants?
Well, it is open to them. If they have a genuine cause to do so, of course they will complain. But I do not see how they can complain in good conscience. They were aware before they joined the civil service about the applicable rules. And of course, it is not as if any impediment is put on their way by the way it has been done for political appointees. So I don't see them suffering any hindrance.
Well, Mr. Kendi Eleja, Senior Advocate of Nigeria, thank you for speaking with us on Sunrise Elite this morning.
Thank you very much. It's my pleasure. Thank you.
Well, we'll take another moment now. We'll be back shortly to talk about students who are on strike as well, protesting and bringing attention to the strike currently ongoing by the lecturers. In just a moment, please stay with us.
Cut out. Section 18 of the 1999 Constitution has amended and encapsulates educational objectives of the federal government. The federal government has failed and now is on strike. Intelligent Nigerian students have been kept into a sit-at-home situation for more than 3 months. And what the federal government has only done is to show an apathetic attitude. The current Speaker of the House, Senate, Speaker of Senate, what he had to say in respect of our plight is that we should not disrupt the election process. That is, I mean, heart-rending.
I want to thank you for this peaceful demonstration, at least to let the public know that what is being done to you, you don't like it. Those who don't know, now know. And I want to tell you that now you are here, your message is quite clear. We will take your message to the appropriate quarters. We are taking your message to the appropriate quarters. And what we need to do, we are going to do. And I can assure you that every person here, 80% of the people here are parents, and a good number of them have children in the higher institution. We are not happy that ASUU is on strike.
President, Student Union Government of University of Benin, joins us via Zoom this morning. Good to have you on the program, Foster. I'd like to ask you, listening to some of the agitations from students and, of course, the response they have gotten, it will seem the lecturers say they are, affected as well because they have children. Even government officials involved have said, well, I have children in school being affected. But I wonder for you now, with this agitation, which you have carried on for a few days now, do you think the message is really hitting home?
Okay, and good morning, and thank you for having me. And first, I would want to say, we have heard several times, everybody keeps telling us, I also have children that is affected, I have children that is affected. But if you really have children that is affected, like they always say, then we are not seeing the response that we should get as at now. I remember yesterday while we were protesting, we met so many persons too that said, we are also in solidarity with you. We have children that are affected. But obviously, you don't have children that are directly affected, because if you do, you should know what we feel and you should know how to help us before now. I've met with some government officials that also told me we have children that are affected. 4 of my children are in university, they are also affected. But I just see these are all fallacies and lies just to make us feel better. But we don't want compliments to make us feel better. We just want to go back to our classes. We have stayed at home, and today is making it 92 days. Today is making 92 days we are staying at home, and next week, Wednesday, we'll be celebrating our 1 year and our 100 days anniversary of staying at home. So obviously, as at now, we just want to go back to school, and we feel the best way for us to do that is to let the world and everybody know we are tired of staying at home.
Clearly, there will be nothing really to celebrate on that day, and I think for a lot of Nigerian students, February the 14th will not, carry that same memory for them. But I know there have been meetings. Just last week, there was a meeting between you know, the chief of staff to the president, the minister of labor, you know, ASUU and other labor unions. It was a tripartite arrangement. And I didn't quite see students right there. So I also want to know, what is the game plan here to ensure that at least, yes, you can agitate, push your demands forward, but at least you're also represented on the table where these decisions are made. They've said when two elephants fight, it's the grass that suffer, but I keep making the case that students are no more grass in this case. They should also be elephants. So what is the plan?
Yeah, I think that's a very, very nice one. And I think through this means and medium, I definitely hope that the approach authorities should hear it and consider that. Because I feel that's one of our problems we are facing right now. Even as it stands now, we don't even know it's our problem. We don't even know it's stopping us from going back to classes. We are eye glued to our phones, only for us to read today that is the ASUU that is refusing to accept the demands, that is refusing to accept the plea of federal government. On the same vein, we also hear from ASUU that federal government is not even offering anything. So we don't even know what's on ground. We don't even know their discussion. We don't even know the length at which our discussion has been set so far. So I feel at this point, it's also sacrosanct that students and bodies should be represented in the meetings. Let's know what our problem is exactly. Let's know those that is not making us go back to our career. Let's know those that is feeling so reluctant about our academic work and our academic activities. Rather, don't.
Oh dear, we lost the connection with Foster. Just when I was about to ask him how much this has taken a toll on his, you know, life. And okay, Foster, you're back. Please go ahead. I'd like you to just add in a minute as we wind down, just how much of an effect, a negative effect, is this strike having on you, your other colleagues? What is this doing to you and perhaps your ambition in life?
Okay, firstly, I will start by
the connection is not friendly this morning, and well, we have to anchor at that point. Clearly, the conversation is not over, so we'll take this as a conversation starter, and I'm hoping those in government, those who are stakeholders in this, are taking this on board. But I'd like to thank you so much, Foster Amadine, who's the President, Student Union Government, University of Benin, joining us via Zoom this morning.
Well, the conversation is definitely not ending. But before we go, let's ask that question of the day one more time. Have you registered for and picked up your voter card? Now, I think it was about 2-3 weeks ago, we had this conversation around the continuous voter registration and what you need to do, where you need to go, you know, to get these things done. Just that website is there, right there for you, cvr.inecnigeria.org, or the nearest INEC office to you, to do the needful, because at the end of the day, you're the one employing people to run your life.
Well, there you go. So the voter card is beyond just an identity card. I know people use it as that, but it's our employment card. We need to get it and ensure we make our votes cast. In the meantime, sorry?
I was going to say that who knows, that card may, you know, change the direction of your life for the next 4 years. So it's very, very critical for you to pick up your voter card.
I'm not sure if Mark agrees with you guys.
I'm sure she does.
Ayo, why are you trying to put words in my mouth this morning? Anyways, we'll take that offline. I was just going to say that the question is not just for you, it's also for the four of us on this program. So don't worry, it's also a question we'll be answering in the coming days by presenting evidence whether or not we too have registered to vote. No hypocrisy here. Yeah. Well, thank you for watching this morning. I'm Maokwe Ogun Yusuf.
I'm Kayode Okikelu.
I'm Bukola Samuel Webimo.
And I'm Ayo Makinde. Have a wonderful day.